Hello future legal eagles. Welcome back to another video where we break down and explain complex legal concepts in simple terms. Today's case is going to be a classic. We will explore the famous case of Partridge versus Crittenden, also known as the Bramble-Finch case, published in 1968. This English case is a cornerstone in contract law and helped define the rules around advertisements, offers, and invitations to treat. The facts of this case are pretty simple. In July of 1968, Mr. Partridge placed an ad in a magazine that read, "For sale, rare exotic birds." A few days later, he received a letter from Miss Crittenden, who wrote, "I am in receipt of your advertisement in the August issue of Bird Keeper magazine, in which you are advertising Bramble-Finch cocks and hens 25 shillings each. I would like to purchase one Bramble-Finch cock and one Bramble-Finch hen from you at the price of 25 shillings each as stated in your advertisement. Please send me the birds and invoice me." Now, normally when one of my clients sends a letter like this, I tell them to sit down, relax, and I take care of the rest. But this is a made-up scenario, so I have to do my duty as a lawyer and point out that there is a problem here. What's the problem, you ask? Well, this is where things get interesting. When Mr. Partridge received Miss Crittenden's letter, he decided not to sell her the birds. Instead, he wrote back saying that he had no intention of selling the birds to her. He said that he had other customers to whom he intended to sell the birds first, and that she should look elsewhere. Miss Crittenden was not happy with his response, and she decided to sue him for breach of contract. She argued that the advert in the magazine was an offer which was accepted by her letter, and therefore he was legally bound to sell her the birds. So did he breach contract when he refused to sell the birds? This was the classic battle of offer versus acceptance. Remember that in contract law, a valid contract requires an offer and acceptance. An offer is a definite promise to be bound by specific terms once accepted. Acceptance is the unqualified assent to the terms of the offer. However, an invitation to treat is not an offer and hence cannot be accepted to form a contract. Shop displays, catalogs, and advertisements are usually considered invitations to treat. So the question here is whether the advertisement in the magazine was an offer or an invitation to treat. To answer this, let's look at the rule. One of the most important rules in contract law is the intention to create legal relations. This refers to the intention of the parties to be legally bound by their promises. Advertisements are generally understood to be an invitation to treat, not a definite offer. This is because advertisements are often addressed to the public generally, and it would be unreasonable to expect the advertiser to be bound by every response. Imagine if every advertisement in a newspaper or magazine became a binding contract. There would be chaos. Sellers would be inundated with contract claims from people who merely saw the advert and wanted to buy the product. This outcome would be impractical and absurd. Furthermore, advertisements allow for some flexibility in negotiations. If an advertiser intends to make a genuine offer, they can clearly indicate this in the advertisement. Potential buyers who see the advert can then decide whether or not to accept the offer. If they do, a contract is formed. In applying this rule to our facts, The court ruled that the advertisement in the magazine was an invitation to treat. The court stated that advertisements are generally addressed to the world at large and are not intended to create a contractual relationship with any particular person who may respond. The court went on to say that if an advertisement is intended to be an offer, it must contain all the necessary terms of the contract and must be clear and specific enough to be accepted without further negotiation. In this case, the advertisement was very general and did not constitute a binding offer. The court concluded that Mr. Partridge was not guilty of offering the birds for sale, and therefore could not be convicted of the offence. This case is one of the foundation stones of contract law because it clarifies what is required for a valid offer. It also helps us understand how the courts interpret advertisements in the context of contract law. As future lawyers, it is essential to know when something is an offer and when it is merely an invitation to treat. If you want to learn more about contract law, make sure to check out our other videos. And don't forget to like and subscribe. Until next time, remember to stay curious and keep those legal eagles soaring.